for joining us for Conversations with Ted, a conversation among attorneys here at the law firm of Taylor English Duma. My name is Jonathan Wilson, and I'm a partner in the corporate M&A and securities practice. And with me is my colleague, Mitzi Hill. Mitzi, tell us a little bit about yourself.
Hi, I head up our data security and privacy practice and have been in this area for a decade or more.
Sure. And today we're here to talk about the Corporate Transparency Act and some of the conflicts that parties may have under that law with the obligations they may owe under European data privacy laws. Now, if you saw our last episode, you know that the Corporate Transparency Act is a new law, and once it takes effect, companies in the United States, roughly 25 million of them, are going to have to file a document with FinCEN, an agency of the U.S. Treasury Department, that identifies very specific items of personally identifiable information about every beneficial owner of the company. So in a corporation, that would be all of the shareholders who are owners. In an LLC, that might be all of the members who are owners. And the challenge is that that information that this new U.S. law mandates be filed could very well conflict with some of the same duties, some of the duties that companies have under the EU data privacy laws. So, Mitzi, tell us exactly what are these EU privacy duties and how could they conflict with the Corporate Transparency Act?
Well, the EU in 2016 passed a privacy regulation that covers the entire bloc, not just certain member countries. And it imposes a duty on anybody who is dealing with European citizens, essentially, to keep personal data about them private, secure, and confidential. And it imposes restrictions and rules on exporting their data out of the EU and into the US. And it requires that if you're going to either collect or use in any way, or process in any way, or transport in any way their data out of the EU, you have to jump through a fairly rigorous set of hoops that are designed to give notice, to give control, and to provide some transparency and assure some security and confidential treatment to the data of those EU citizens.
So I guess to give us a hypothetical to work with, let's say that we have a U.S. corporation and it's got 4 shareholders. Maybe 2 of those shareholders are here in the United States, and then 2 are residents of EU member companies. The Corporate Transparency Act says that that corporation would have to file a beneficial ownership report that includes name, date of birth, the residential address, and the documents for each of the 4 individuals. How would that conflict with that same corporation's duties under these EU privacy laws?
Well, believe it or not, their address, their photograph, if we've taken pictures of, say, their passport or their driver's license in order to confirm their identity for the CTA purposes, is considered their personal data, and it is protected by the GDPR, even though they are giving it to you in a work context. And so in order to take it, bring it to the US, and disclose it to a US regulator, you have to have their permission, or you have to have another, what's called legal basis under the law, to do those things with that data. Most companies that collect data from EU-based employees are going to try to establish that they have a legal basis, such as compliance with the US law for a US filing requirement, but they may also try to obtain consent from those affected employees or individuals. You definitely have to give them a written notice of what you are collecting from them, why you are transporting it to the US, to whom you are disclosing it, and the legal basis for all of those actions. And you also have a duty to keep that information secure, including if you have any service providers who would have access to it along the way. There may be some other things that you have to do as well, but that would be kind of the starting point for how you would have to treat data of these individuals who are based in the EU.
Sure. Now, in your answer, you talked about duties that the corporation owes to employees for the employees' personal data. What about in the hypothetical where the shareholder of the U.S. corporation is an EU resident, but that shareholder is not also an employee of the corporation? Would the EU data privacy laws still apply in that context?
It's a great question, and the answer is yes, it would. In that sense, it's a little easier than US law because the EU laws apply equally to all individual people the data of all individual people, regardless of what their relationship to you is. So whether it's an investor or an employee or a customer or someone who walked into your building lobby and got caught on your security camera, you sort of owe the same notice, protection, confidentiality, all of the same duties apply to any personal data about those people.
Sure. On the corporate side of things, I've been telling clients that in order to prepare to comply with the CTA, they ought to add clauses to their shareholders agreements, to their LLC operating agreements that state that the corporation is going to try to comply with the CTA, that every member, every shareholder is going to have an obligation to give their data to the corporation to go into the beneficial ownership report, to put some corporate governance guardrails around that entire process. If we had the right language in a shareholders agreement, operating agreement paragraph like that, would that language be sufficient to satisfy your notice requirements under the EU data privacy regulations?
Under the EU data privacy regulations, you probably need more than a paragraph, but yes, you can include that kind of language in those kinds of agreements. You also could do if it's easier for you to administer, you also could do a separate standalone notice that is simply a notice of privacy practices. For example, when you give those shareholders the FinCEN or the CTA reporting form and say, fill this out, you could deliver them a privacy notice that says, here's what we're collecting and here's what we're doing with it. And so whichever kind of is easier for you as a company, I think is probably adequate.
All right. And I imagine because this area of the law is evolving so quickly, both as it relates to the CTA as well as to data privacy in Europe, clients are well advised to consult with counsel to run through their specific situations to make sure they're as protected as they can be from any unforeseen outcomes.
I think that's right. And, there are a few tricky areas about this law. One is the kinds of protections you have in place to transfer. The other to note is that this doesn't apply just to people who are European citizens. It applies to any data you collect in the EU. So if your investor is American, but lives in France permanently, for example, and is submitting their information to you from France, the fact that they are an American citizen is irrelevant for purposes of the EU data protection laws. They are just as protected. And there are a lot of little wrinkles like that that make it worth figuring out what the exact facts of your collection will be and how the law applies to them and how best to comply with your obligations. Because the penalty for non-compliance can be fairly steep in the EU.
Got it. All right. Well, Mitzi, any concluding thoughts?
No, I appreciate the time to talk about this. I think it's going to be really interesting to see how these various regimes bump up against privacy laws around the world, because the EU is not the only country or the only area with privacy laws like this. And this is an increasing part of doing business no matter where you are in the world.
Absolutely. And on the Corporate Transparency Act side of things, we're still waiting for FinCEN to give us their final regulations. So exactly how that's going to play out is something we don't yet know. So listeners are well advised to stay tuned and stay abreast of these developments. I'm sure we'll be covering them here as they come out. But for those of you watching, thank you for joining us on this episode of Conversations with Ted, focusing on the Corporate Transparency Act and European data privacy concerns. If you have any questions, please reach out to Mitzi Hill or to me, Jonathan Wilson, here at taylorenglish.com, and we look forward to speaking with you again in the future.